In 2003, Susan M. Reverby, a professor at Wellesley College, unearthed a long-forgotten unethical medical experiment conducted over half a century ago among dusty files in Pennsylvania Archive. Starting in 1946 and until mid-1950s, the U.S. government conducted medical experiments in which over 5,000 uninformed and unconsenting Guatemalan people were intentionally infected with bacteria that cause sexually transmitted diseases. The study involved vulnerable populations in Guatemala, including children, orphans, child and adult prostitutes.
And the goal of the research was to determine whether taking penicillin after sex would protect against those sexually transmitted diseases. It was a medical priority at the time, especially in the military.
Y me acostaron en una camilla. Entonces un doctor estaba de este lado y el otro, y la enfermera me tenía agarrada la cabeza. Entonces ellos hicieron por abrirme las piernas, ¿verdad? Y yo no quería. Entonces yo como niña de 10 años con sus fuerzas que podía tener, ¿verdad? Yo no quería y no quería, yo hacía lo posible porque no. Entonces ellos decían, no se puede, no se puede.
After this reprehensible medical experiment was revealed, the victims brought a class action lawsuit against the U.S. government under the Alien Tort Statute, 28 U.S.C. Section 1350.
The Alien Tort Statute, what we refer to as the ATS, is a very old statute. It dates back to 1789, and what it does is it allows non-U.S. citizens to sue in U.S. courts for violations of international law.
Terry Collingsworth is a Washington-based human rights lawyer representing the Guatemalans who've emerged to file a class action lawsuit against the U.S. government.
The fact that they went to Guatemala is partly, at least, due to the fact that everyone understood that Guatemala was a place where there were no rights for poor people or people in prison, and that you could pretty much do what you wanted with them. So to take advantage of that kind of situation certainly multiplies the crime.
However, the case was never heard on its merits and was dismissed for failing to state a legal claim on June 12, 2012. After the lawsuit against the U.S. government got dismissed, the victims sought a different recourse. They filed a new lawsuit accusing Johns Hopkins University and the Rockefeller Foundation for conducting the study in Guatemala from 1945 to 1956, and Bristol-Myers Squibb Pharmaceutical Group for supplying drugs for the experiments. It was initially dismissed last year, but U.S. District Judge Marvin J. Garbus has allowed to move forward in August 2017.
Well, I think they've gotten over sort of the major initial obstacle to be allowed to go forward, which is great. I think that in the future, among the obstacles, and there are many, is that this happened a long time ago, and so you have getting the evidence together to prove the case, I think, is going to be difficult. It's going to be difficult to get that information from Johns Hopkins and Rockefeller. It's going to be difficult to get it from the victims.
How does this case reflect upon our tort system? First, we have to understand how this horrific experiment could have happened in the first place. The treatment of syphilis and other venereal disease became of great interest to the United States during the early to mid-20th century.
But I imagine, for example, that the scientists, that the government officials involved felt like their interest in seeing whether or not penicillin would be kind of powerful in a certain way overrode the interests of the people who they were experimenting on. And in order for that to happen, you obviously have to have a very particular view about the value of these people's lives, the value of these people's health, sort of who they are and what the cost to them is versus the great outcome that you think you might get by running these experiments.
In tortious cases like this, in-group and out-group dynamics can play an incredibly important role. Here, the American scientists likely view the Guatemalan subjects as the out-group. Thus, the harmful effects inflicted upon the Guatemalans fell outside of the doctor's scope of justice. The doctors likely viewed the benefits to their in-group by achieving medical breakthroughs as substantially outweighing any negative costs to the Guatemalans. In fact, this wasn't the only syphilis study on an out-group that we saw in this era. The Tuskegee experiment had already begun when the Guatemalan syphilis experiment took place. However, the Tuskegee victims received a $10 million settlement. It is important to note that Tuskegee victims had more political backing and legal options. The Guatemalans are in a different situation.
And they don't really have important political backers. I think that's really the main difference. I think they suffered the same kind of abuse.
One may wonder why it took so long for claims to be brought regarding this experiment. One explanation may be the obstacles that the plaintiffs faced in going through the steps of naming, blaming, and claiming. For one victim of this experiment, Federico Ramos, he explains that because he did not know he was subject to experimentation, he was unaware of what caused his health problems and failed to receive a proper diagnosis. Like Ramos, many of the infected were uninformed. Years later, Ramos was able to discover that he was suffering from gonorrhea. Finally, he had a name for his ailment. It is clear that the individuals who were medically experimented on, especially those who did not provide consent, could be considered situationists or balls. However, the dispositionist actors, the sticks, in this scenario the United States and other researchers, have so far been able to evade liability. The United States and the individuals working directly for the government have been considered immune from prosecution due to sovereign immunity in relation to the alien tort claims brought against it. The tort system has been thought of as a mechanism that can provide some form of relief for those who have been wrongfully injured. At this point, the tort system has not been able to provide relief to the victims of the Guatemalan experiment, but there is hope for the victims as the current lawsuit moves forward. However, the outcome of this case may prove to be important not just for the victims, but for the tort system as a whole.
There was another case involving the Pfizer company in West Africa where people were given drugs without their informed consent. So I think, unfortunately, some American companies or research institutes thought that they could take advantage of people in other countries without giving them that kind of informed consent. And maybe in this case it's a product of the 1950s, one would hope. But the Pfizer case indicates that even as recently as the last decade or so, drug companies believed that they had the right to do what amounts to medical experimentation on people without their informed consent. So I wouldn't be surprised if it's still going on in some places, which is one of the other reasons why the case is so important, so that it could stand as a deterrent to that kind of behavior in the future, which I think is also one of the purposes of the tort system, right? To impose costs on tortfeasors that will lead them not to engage in that kind of behavior in the future.